Good morning, good afternoon. This is Mary Laplante. Thanks for joining Digital Clarity Group today in our first private clients-only briefing on customer data privacy and the impact of mandates such as the General Data Protection Regulation. As clients with whom we work closely, you know that DCG has devoted deep coverage to data privacy issues for several years now. In early 2016, Tim Walters, with whom many of you work on a regular basis, came to the team and said, hey, you know, I think we should be paying attention to this new EU regulation. It's likely to have significant impact beyond basic compliance requirements. Fast forward 15 months or so, the impacts, effects, and consequences have been taking shape, and buyers are increasingly aware of what's at stake with GDPR compliance. Not only are they aware, but they're also taking action. Here's some anecdotal evidence from just last week. We presented on the new wave of privacy concerns at the CMO Summit in Austin, Texas. George Corbin, who was Senior Vice President Digital at Marriott International, was in our workshop. He readily shared what Marriott is doing and must do in response to the GDPR. The reaction on the part of the rest of the audience, comprising senior marketing and digital leaders, was qualitatively different. It's one thing to hear about the GDPR from an analyst, but it's a completely different thing to hear from a digital leader at a major global brand. We're seeing this determination to abide by the rules of the GDPR in more and more of our conversations with our buyer clients. In some cases, like Mr. Corbin's, companies are thinking beyond compliance and seeing GDPR as an opportunity that's woven into their larger digital transformation initiatives. Tim and I are here today to help you understand what's at stake for you as a technology vendor and for your customers when they select technologies for their experience management and digital transformation initiatives. This private session isn't meant to introduce you to the GDPR. We have a lot of other resources that will help you do that, but rather to dig into the specific parts of the regulation that will put you, that are putting you behind the GDPR 8-ball. Because this is a private client event and we do have some competitors on the phone, we're not doing open mic Q&A, but you can submit a question in the question box on your console, and Tim and I will take it if there's time towards the end. He's planned his remarks for about 30 minutes, I think that's right. Today's session is being recorded too, and so if you'd like to share what we discussed today with your colleagues, you'll have a link to the webinar. And with that, Tim, I am going to turn this over to you.
Great, thanks a lot, Mary, and welcome everyone. Specifically, we're going to be talking almost exclusively about the provisions in the GDPR regarding data protection by design, which is in Article 25, and very importantly also in the supporting recital number 78. Let me begin by simply saying that I'm not a lawyer. I necessarily am going to be interpreting the text of the GDPR, trying to help myself and you understand exactly what's going on in some of the more obscure passages regarding data protection by design, but this is not legal advice and you should take your own course when necessary. Let me begin just by setting the stage with some framework and some of the misconceptions that I still encounter on a regular basis, even among people who quote-unquote should know better, such as at a privacy conference in Berlin a couple of weeks ago. One, time is frankly running out, 408 working days from today before the GDPR comes into effect, 282 working days. If you haven't started yet, that is you or your clients, you're already not going to be able to be fully compliant, very likely. But what you do have an obligation to do is demonstrate that you made a good faith effort to be as close to compliance as possible by May 25th, 2018. I keep hearing, and frankly I hear this very often from vendors, that the regulators are going to soft pedal the enforcement in May of 2018, that because of the effect on the economy or it will be too disruptive for business and so on and so forth. This is quite frankly a delusion. This is a direct quote from one of the top commissioners at the UK Information Commissioner's Office, that is the Data Protection Authority for the UK. Will there be a grace period? No, there will not. Why not? Well, frankly, because we are already in a 2-year grace period. the bill was passed or the regulation was passed in May of 2016, and you have until May of 2018 to get ready for it. If you have not done so, you will be at risk for prosecution. Also, I hear this very often in Germany in particular, because the Germans are rightfully very proud of their current very rigorous data protection regulations. Nevertheless, the GDPR is not some kind of minor variation of what exists in the EU presently. For one thing, there is no single EU policy at present. There are 28 different sets of regulations in the 28 member states. But just look at the list here of what are new requirements in the GDPR compared to the current legislation that is directed by what's called the Directive 95. Very, very importantly, although I said legal counsel certainly has to be involved, it is not just a matter for compliance and legal. It is kind of unfortunate that this thing is called a regulation. I mean, obviously it has to be, but way too many companies look at that and they say, oh, another regulation from the EU. Who takes care of regulations? The compliance department takes care of regulations. But look at these quotes. These are very, very valid, I think. It's not an IT responsibility. It's not a compliance responsibility. It's not a legal responsibility. All of those have to be involved, and so do every line of business, including marketing, including the top executives, including the board. It's a company responsibility. It's about a culture shift within every organization. You guys as vendors, and maybe we have a service provider or two on the in the audience as well, especially if you're involved in providing cloud services, it's very, very likely that your companies are both data controllers in your own business activities and data processors. That is, you're taking orders from data controllers and processing the data. I was listening to a podcast on the shift from deterministic computer programming, that is writing code to tell the machine what to do, to probabilistic programming, and it struck me that old-fashioned current deterministic programming kind of marks the distinction between a data controller and a data processor. The data controller determines what should be done with the data, and the processor carries out those orders. It processes. As processors, if you are a processor, it's very plausible. It's possible that the financial impact of non-compliance could even be greater than that 4% of your global income, global gross revenue that's called for by the GDPR. Why? Because of this argument from my colleague Todd Ruback at Evidon. Just points out that in this case, if a publisher is fined 4%, so let's say a big publisher like the Washington Post, New York Times, if they're fined 4% of their global revenue because of the activity of a processor, they are going to try to claw back that 4%, and it might be 40% of the processor's global revenue or whatever, right? That number becomes immense if we're talking about, when we're talking about the discongruity between a very, very large controller that receives a fine under the GDPR and a relatively processor that has to indemnify that controller. Okay, this is all we're going to talk about today is data protection by design. It's called data protection by design in the GDPR. It is more widely known as privacy by design. It was developed as privacy by design by a woman named Anne Cavokian, a Canadian, who was, at the time, I guess, or at least later, or maybe previously, Ontario's privacy commissioner. And it simply requires that data protection is embedded from the outset into the development of any technology or any business process. It's not just about, most of the material, if you start looking, Googling privacy by design, most of the stuff that comes up will be about what developers and engineers should keep in mind when they're creating new technologies. And that's all true, it's all very important, but it also extends to business processes. For example, every marketing campaign, as soon as someone approaches a whiteboard with a marker in their hand and says, hey, I've got a great idea that we might be able to engage our customers better if we use their data to, and puts a mark on the board, you are obligated to be thinking in terms of data protection by design. Okay, the quote here from Ann Kavokian, privacy must be approached from a design thinking perspective. Okay, privacy must be incorporated into systems and technologies by default, et cetera, et cetera. And another quote from a very, very interesting and very long recent report from City GPS. It's about essentially embedding the protection of personal data into the DNA of companies. And just ask yourself where your companies are, and more importantly, where your dozens or hundreds or thousands of client companies are. Can we really say that they currently have protection of personal data embedded into the DNA of their companies? Article 25 is the article within the GDPR that talks about data protection by design, as you see here, and by default. However, as very often happens in the GDPR, more insight and more clarity is granted by the so-called recitals that come before the articles and support the articles. The recitals are not themselves legally binding, but they will be used to help data protection authorities and users like yourselves understand what the articles mean. And they typically, the articles, the recitals provide a lot more information than the articles themselves. The articles are kind of boiled down versions of the recitals. So what we want to look at is recital 78. And it's long and imposing and so forth. Only two parts of it really are important for our discussion. That is these two. So let me just read these, bear with me. In order to be able to demonstrate compliance with this regulation, the controller, and I think this means also processors, should adopt internal policies and implement measures which meet, in particular, the principles of data protection by design and data protection by default. Okay, that's relatively clear, I think. Now comes the odd and slightly agrammatical sentence. When developing, designing, selecting, and using applications, services, and products that are based on the processing of personal data or process personal data to fulfill their tasks, producers of the products, services, and applications, that's you guys, should be encouraged to take into account the right to data protection when developing and designing such products, services, and applications, and with due regard to the state of the art, to make sure that controllers and processors are able to fulfill their data protection obligations. So what does all this mean? One, the first sentence that I quoted simply means, I think, in order to comply with the GDPR, data controllers and processors must adopt and practice and be able to demonstrate that they have adopted and practiced data protection by design and default. And we'll see in a moment what that might mean. Secondly, the more confusing sentence, vendors and service providers, that is producers of products, services, and applications, one, should be encouraged to take into account the right to data protection when designing their products and services. And secondly, should be encouraged to make sure that buyers, that is controllers and processors, are able to fulfill their data protection obligations. This is a strange formulation, should be encouraged to make sure. Okay, what does that mean? Taking it a step further in the hermeneutical exercise of my wife poring over my various hard copies of the GDPR, thinks I'm a Talmudist. In order to meet their obligations under data protection design provisions of the GDPR, buyers may purchase and use services only from vendors who can demonstrate that they, quote, enable data protection by design. In other words, vetting for that capability has to become a central part of any selection process going forward. Any selection process that you're involved in, whether it is for your software services, your software products, your cloud-based services, your service products if you're a service provider, and so forth. That is, I say it has to become, vetting for support of data protection by design has to become a central part of the selection process, because the buyer who's running the selection process has to be able to demonstrate to the data protection authorities that they carefully vetted all of the providers who are contributing to any process that processes personal data. Okay, and it's very important to know, we're not going to talk about it here, but there's so-called accountability provisions of the GDPR. And as I've said, that means that they have to be able to demonstrate, to document and demonstrate to the data protection authorities that they undertook such careful vetting. So if they are not undertaking such careful vetting, and probably most of them aren't yet because they don't realize they need to, they will be soon. And frankly, I think from a competitive positioning, and I'll tell every one of you this, although some of you are competitors, if you get into a selection process in which the selector, the buyer, is not properly vetting for data protection by design, you should bring it to their attention and highlight it, assuming that you know that you're able to answer all the questions and demonstrate your own support for data protection by design, because that could potentially give you a competitive advantage. Okay, what is data protection by design or privacy by design? These are the 7 foundational principles of privacy by design, as I think as formulated by Ann Cavokian, but in any case as they evolved after she initially formulated them. I won't go through each one of these, but you can see privacy is the default setting. Privacy is embedded into the design. Privacy should be a positive sum game, not a zero sum. It's not about privacy or security, right? Or privacy or for that matter, privacy or personalization within your business processes, but you need to try to strike a balance that allows you to achieve both. But what's important is that, yes, these 7 foundation principles are important, but I think that when it comes to a data protection authority determining whether whether a controller or whether a vendor who is assisting a controller has demonstrated sufficient support for data protection by design, they're going to look again back at the GDPR itself because these foundational principles are entirely outside of the GDPR. So now we go back to Article 25 and look at the second paragraph. Again, I'll probably end up reading all of this, but it's not all that. What I want to emphasize, I'll tell you what I'm going to emphasize afterwards. The controller shall implement appropriate technical and organizational measures for ensuring that by default, only personal data which are necessary for each specific purpose of processing are processed. This obligation applies to the amount of personal data, the extent of the processing, the period of the storage, and as the sentence goes on, it basically also applies to the number of people who should be exposed to that personal data. All of these things, in other words, are, I mean, everything that they're talking about here is what's called data minimization and storage minimization and purpose specification under the GDPR. Where are those things discussed? They are the 6 fundamental principles in Article 5. This is the heart of the GDPR, these 6 fundamental principles. This is what the data protection authorities are going to be most concerned about, that you are following, you're able to demonstrate these kinds of behaviors. And again, we won't go through all. See there, purpose limitation, data minimization, accuracy, storage limitation, and so forth. Okay, so I'm going to draw a few conclusions. Mary, anything that I've missed, do you think?
No, I think I have a couple of comments, but I'll save those to the end.
Okay, great. So as controllers, that is in the operation of your own businesses, trying to sell software or trying to sell services to clients, assuming that you're doing this in Europe, then you obviously must comply with the GDPR, and that means also following the principles of data protection by design in any business process that you operate that touches personal data of EU residents. Very likely, again, not legal advice, but it's very likely that if you're operating cloud services, that makes you a processor for at least some of your clients and potentially hundreds of clients, and therefore you have the same implications for compliance with the GDPR. As vendors, and this is my main point of this webinar, you must be able to clearly demonstrate that your products or services support the buyers, should be a possessive comma there, that the buyer's obligation to data protection by design. That's what they need to be asking you during the selection process, and you need to provide a clear and convincing response to those questions that they ask during the vetting process. Very important, data protection by design is not only or primarily a technical issue. And I say despite the German translation, it is about a design thinking approach, as we saw Ann Cavokian's quote at the beginning, a design thinking approach that pervades the entire business process. And here's why I'm picking on the German translation. The translation in German is Datenschutz durch Technik in recital 78, or Datenschutz durch Technikgestaltung in Article 25. That basically means data protection by technology, or data protection by technical engineering or technical design. And the last thing that you want to believe, or to encourage anyone else to believe, is that data protection by design is a technical problem that will be taken care of by engineers somewhere. Yes, they'll be involved again, but so will a lot of other people, because it is about the entire business process. In the GDPR, data protection by design isn't just about those 7 principles of data protection or privacy by design that were drawn up by Ann Cavokian and others after her, but I think that it extends further to embrace the fundamental principles of data protection that are articulated in Article 5. So it's not, it's not a box checking exercise by any stretch of the imagination, as we saw in one of the quotes. And compliance, by implication, compliance with data protection by design and the GDPR more broadly requires a fundamental transformation in business culture that is for you as vendors and service providers, and obviously because it implies that for your clients. Okay, I won't read through any of these, but this is a quote from the UK Information Commissioner's Office from the Commissioner herself, who happens to be Canadian, and I assume very closely aligned with the principles, if not the person, of Ann Cavokian. And she says it means a change to the culture of an organization. And it turns out that in that city GPS report that I mentioned earlier, they have interviews with a number of industry representatives. At the end, Andrew McKellen is with IMRG, which is a retail group representative, a group that represents retail businesses in the UK, and he says the majority of the change needs to be cultural rather than box ticking. I'm just reiterating, this isn't just a compliance problem, it's a cultural change problem. Okay? For many organizations, it may require revisiting the core business model and making sure privacy considerations are considered afresh. Okay, this is probably the next to the last slide, I think. My advice, act now. You should have started, should have at least started in May of 2016. You probably should have started even before then, because we've known since at least December of 2015 that the GDPR was going to come into effect. You need to impress upon your clients and upon your own internal business operations that the budget planning cycle that's going to be started, in a few months at the latest for 2018, that's the last chance to set aside a sufficient amount of funding to deal with the transformations that are necessary in order to be compliant with the GDPR. We advise you quite frankly to schedule a GDPR advisory with someone, we provide them, to thoroughly understand the regulation and to begin to plan your response. That is your response in terms of positioning, market positioning, if you can achieve some kind of thought leadership, if you need to, if it has implications for your product design, your product roadmap, product positioning, and so forth. And do understand that doing nothing, that is, we'll deal with it later, right, will take care of it on May 26, 2018, that is effectively already itself a violation, because you have a responsibility to be accountable for the fundamental principles of the GDPR. And if you do nothing, that is, if you don't make let's put it this way, what you are obligated to do is make a good faith effort to be in compliance. If you're not able to demonstrate that you at least made a good faith effort, that you effectively did everything that you possibly could or reasonably could, then you're likely to be found in violation for not taking it seriously, basically, not being accountable for your obligations under the GDPR. That's it, and I think we're well under a half an hour, and I'd be happy to hear Mary's comments and take any questions potentially.
Great, thanks, Tim. Well, my first comment actually has to do with the information that you provided on slides 12 and 13, and I love the quote from IMGR and Citi, and this is a callback to what we heard George Corbin from Marriott say. And that was, hey, you know, as part of what we're doing at Marriott to make sure we're complying, we are digging into our infrastructure. We are looking at the technologies and the services and the processes. I mean, we're going down to bedrock here on understanding what this is going to take. So, you know, this is just another piece of evidence that leaders who are taking this seriously are, you know, they're pulling their infrastructures apart to make sure that they're going to comply. And again, there's also the, you know, what you haven't talked about here, which we've mentioned just briefly, is, you know, there are some companies who are thinking about this in terms of, well, maybe I could sort of do this as part of our larger digital transformation initiatives, because in fact, we should be relooking at the way we're managing our engagement with our customers. I mean, we're looking at that anyway.
Absolutely. And that, you know, that comment from Corbin, that they're basically rethinking or reviewing and evaluating their entire infrastructure, that tells you how much of an opportunity that compliance represents for vendors and service providers.
Exactly. Exactly. And, you know, one thing you didn't mention, the study that's being bantered around that. In fact, I used it in the invitation to some of our participants today. But the PricewaterhouseCoopers study that indicates that 92% of leaders in the U.S. are looking at GDPR compliance as a priority. So again, this reinforces, you know, this responds to one of those other myths, which is, oh, well, we don't have a big presence in the EU, so it doesn't matter to us. Well, no, that's not true.
Yeah, and in that Pricewaterhouse survey and report, they asked people, how much are you likely to spend on compliance? And if I recall correctly, 68% said between $1 and $10 million. And I believe 20-some% said over $10 million. Now, I think that's impressive. Somebody calculated a weighted average, and the weighted average was $4.5 million per company on average. I think that's probably low, because the important thing to remember about that PwC survey is that it was conducted among data security professionals. And they're looking at data security issues, which are, of course, crucial, but only one aspect of compliance with the GDPR. They weren't looking at, you know, what does marketing have to do in order to revise the way that they use data in customer engagement, for example. What new technologies are going to have to be in place for that? The data security guys aren't thinking about that at all. So $4.5 million per company on average for the data security aspects of GDPR, which we haven't even begun to address here.
Right. So another observation I have too, you and I, and I'm going to make a parallel here, you and I have both covered translation, localization, and globalization as analysts at different points in our careers. And one of the artifacts or hallmarks of how companies used to approach that is the whole bolt-on thing. Well, it's okay, we've got our content process over here, we've got our website management processes over here, we'll just bolt on the multilingual things that we need. And we know that has only led to bad experiences. All the seams in that approach show. It doesn't take long before that unravels. It can't scale. So in my mind, I'm seeing a parallel here into the upside of privacy by design. So if compliance and data protection, respect for clients' information is built in, the experience across the board has to be better than bolting it on. Are you seeing in your conversations with vendors and buyers, are you seeing an understanding that, hey, this by design thing really has some benefit other than, another approach we might take?
Yeah. I frankly, I am not seeing it that often. Although I was at a 2-day GDPR event in Madrid a few weeks ago, and there were like 60-some industry representatives there. That is, companies that are going to be affected by it from all over the world, and all the biggest ones: Amazon, Facebook, so on and so forth. And then and a number of the data protection authorities as well, right? Because they want to make sure they're doing everything they can basically to answer questions and concerns and make sure that there's a consistent regulatory enforcement across the EU and so on and so forth. And at that particular event, there was one presentation by a woman from a design firm. And it was about basically using design to attack or solve, address problems and challenges that are raised by the GDPR. And clearly, and not only under privacy by design or data protection by design issues, but in general. And that gets back to what you were saying again about Marriott, that if it's a company-wide effort, then it's a systems level challenge. It's a systems level problem, and you need to look at the system overall. And of course, that's effective at its heart, in my view. That's what design thinking is about looking at the system rather than isolated elements of it. Right.
You've written extensively for DCG about customer experience management as a systems design. So I see some parallels here.
Exactly. Yeah.
We do have a question from someone in our audience, and I'm just going to read this sort of verbatim. The question is, will the UK providers have to comply with GDPR when selling to other UK companies following leaving the European Union? Mm-hmm. This person goes on to say, I understand they will have to comply with selling to other EU-based companies, mm-hmm. but wondering about UK to UK only.
Right. Well, the missing element there is when we say selling to UK, let's put it this way. The answer to the question lies in whether that company that the vendor is selling to, although located in the UK, is itself handling the personal data of EU residents. Are they doing business in affected areas of the EU? Are they doing business in the EU, although they're located in the UK? If the answer is yes, they are doing business in the EU, then they must be compliant with the GDPR. And therefore, it's not the scenario of UK vendors selling to UK companies does not in any way exclude that transaction from the requirements that we've been talking about in the webinar. Also, by extension, although not asked directly here, what's going to happen in the UK after Brexit? And first of all, before Brexit, the GDPR will take effect in May of 2018, and Brexit will be at the earliest in early to mid 2019. So right there's a period in which undoubtedly, beyond shadow of a doubt, all UK companies, whether or not they're dealing with whether or not they're doing business in the rest of the EU, have to be compliant with the GDPR for at least that period. And then every indication is, and I think, although don't quote me on this, that the ICO, again, the UK's Data Protection Authority, has stated recently that post-Brexit, when the UK is in a position to adopt its own data protection regulations, that let's put it this way, it's safe to say that it's very likely that they will adopt something which is essentially equivalent to the GDPR, if not more rigorous. Why? Because if they don't, then they threaten the ability to be able to transfer data from the EU to the UK, just as we currently have problems transferring data from the EU to the US. And the privacy shield that replaced the safe harbor is being challenged, and in my opinion is very likely not to be found sufficient. And the UK cannot possibly afford to get into a position where data transfers can't take place easily from the EU to the UK post-Brexit.
Sounds like a pretty complicated picture to me.
Exactly.
I do have one other observation too. You know, you had mentioned in some of the quotes you had about the cultural issues, about how this is just really not a compliance issue. It's IT, it's marketing, it's culture, it's sort of everything. You know, one of the issues that's bubbling up more and more in our engagements with our buy-side clients is the whole issue of organizational change management. You know, when we engage in a selection or a roadmap development, increasingly it's, Mary, how can DCG also help me with the change management stuff that comes with the introduction of the new technology, the new solution? So it occurs to me that we do have some service providers, some of our service provider clients on the phone, digital agencies, systems integrators. It seems like for those companies who are, you know, helping global brands deal with this issue, competency in change management is going to kind of bubble up here too.
Yeah.
When it comes to helping companies make the internal changes that are going to be necessary to incorporate data by privacy by design into their processes.
Yeah, yeah, absolutely. And I you know, when I think that's the quotations that you pointed to. You know, you might expect a DPA like Elizabeth Denham to say that this is a matter of a change in the culture of an organization. But when you see these guys from the retail group representative and from Citibank, I insist on calling it, when they're talking about and recognizing that it involves basically cultural change, that, you know, that's a good indication that the DPAs aren't just trying to be scaremongers, and that compliance really will involve much more than the kinds of superficial, if you might say, changes that you've typically used in order to comply with this or that regulation. And that's again why it extends way beyond the compliance department and way beyond the legal department, unless those guys have some kind of systematic capability and expertise in change management and corporate cultural change.
Yep. Well, I see most of our audience is shy about asking questions, but given the forum, we encourage you to send questions to either Tim or I. I think, Tim, can you put your last slide up just so folks have our email addresses handy? Send us your questions if you have them after the webinar. Go to the DCG website, by the way. One of the things that works well on our site is site search. If you go to the box in the upper right and type in GDPR, if you're looking for additional resources to share with your teams, some of the basic information about GDPR that Tim did not cover this morning, we have white papers and podcasts and videos and pre-recorded webinars that can be useful in spreading the word internally about GDPR. As a follow-up, we'll be happy to send the slide deck to everybody, and of course, we'll send you a link to the webinar as well. Anything else, Tim?
That's it. Thank you.
All right. Thanks, everybody. Have a great day.
Ciao.